Hello friends, today we are going to discuss the section 13 of the Transfer Property Act 1882, which is transfer for the benefit of a unborn person. So yeah, before we move into the detailed discussion of section 13 of Transfer Property Act, we first must understand who is a unborn person. So if you see here, a person who is already in his mother whom is considered as a living person, so he is not an unborn person. And a property can be directly transferred to him who has already come in the his or her mother womb, so there is no problem in that. But the problem area is the person who hasn't come in the mother womb, he is considered as an unborn person, and he is not existing person as per the law. And there is the problem because as per the section 5 of the Transfer Property Act, it says the transfer must be inter vivos, means the transfer can be happen between two living persons. We cannot transfer a property to someone who does not legally exist. So and that's why a transfer to a unborn person is legally void as per section 13. Now why transfer a property to a unborn person is legally void, we will discuss in the next slide. Okay, now the thing is, the concept of abeyance. What it says that as per a valid transfer of property, the interest of the property, both the possession, physical possession, as well as the ownership, it's must immediately vested from the transferor to the transferee. Say, for example, I am a transfer, I am transferring a property to you. Okay, now in that case, if the property gets registered tomorrow, so from tomorrow immediately the both the interest, physical position, as well as the ownership will be vested to you. You are the transferee, and if you want, from the next day onwards, you can again transfer this property to someone else. But in this case, since the unborn person is not in the existence, so the interest of the property uh, uh, cannot be transferred to a person who is not in the existence, so it's create a abeyance, it creates a vacuum area. And that's why the in the law section 5, it has made this transfer to an unborn person is making void. Okay, now then what is the solution for it? Okay, can transfer can be done to a unborn person? So that's where the section 13 has come, and section 13 is providing a solution by providing a bridge on this problem by introducing a living person, in that using that or introducing the living person where a prior life interest has to create it in the name of the living person. In that sense, transfer can be done to a unborn person. So there are two mandates to follow, and using that, a property can be transferred to them. So to prevent the property falling into this abeyance, the transfer of the property provides a statutory loopholes. The property is structurally supported by a living person until the unborn beneficiary arrives. Um, but as I said, it has a two mandate or two strict non-negotiable condition that meet simultaneously. So what are those conditions? So first condition is that a prior life interest must created in favor of a living person, because the ultimate beneficiary does not exist on the date of transfer. The property vested in the living person intermediary, and then that person will enjoy the property for his or her lifetime. And by the time the unborn person must come into the existence, and then how the handoff will be done, the unborn person must come into the existence before the living person dies, and then he then wait for the possession until the living immediated his death, at which point the property seamlessly transferred to that unborn person. So the property possession of the property or life interest has been created to a living person, and after the death of that living person, the property will be transferred to that unborn person. So this is the first condition where a prior life interest must created in favor of a living person. And the second condition is that when the property is transferred for the benefit of the unborn person, the remaining interest must be transferred to them absolutely. And so creating a restriction or life interest for the unborn person explicitly violates the section 14. So when we discuss the section 14, we will see that for an unborn person, absolute interest must be transferred to him. There would be no life interest can be transferred to that unborn person. Okay, so this is the second condition. So if someone follow this both the mandates, then property can be transferred for the benefit of the unborn person. Okay, now this is a diagnostics, or difference between a standard and a unborn transfer. So if you see the target entity for standard transfer as per the section 5, it would be a living person, and unborn transfer, it's as per section 13, the person who is not in the womb of mother. Okay, so vesting timeline immediate on the section 5, the vesting timeline is immediate, but for section 13 it delayed upon birth and depends upon immediate death. And required interest type, so for standard transfer under section 5, it can be life interest, restricted, or absolute interest. But for unborn transfer under section 13, it would be only absolute interest. Transfer mechanism in section 5, it would be a direct transfer mechanism, and for section 13 unborn transfer, it would be the indirect, require a prior life interest, as we discussed. So section 13, it's not a separate type of property law. It's a highly controlled and tightly regulated exception to the standard rule of inter vivos transfer. Now we are going to discuss a landmark case study. We call it the Girish Dutt versus Datadin case. So we will understand the section 13 in details in this case study. Okay, so what exactly happened is, say I am a transferor and I am A. Okay, so I transfer my property to my nephew's daughter, who is considered as a B here. Okay, so I transfer my property to my nephew's daughter, and the life interest is vested on her. And with the condition is that if my nephew's daughter having a male child, so the male child would be the will get the absolute interest. If she will have a female child, then life interest will be vested on her. And if she dies issueless, then the property will be reverted to my nephew, A's nephew. Okay, so now this was the, as per the transfer deed, these were the terms and condition. Now what happened is that, as I said, I make the give property to my nephew's daughter B and her life for her lifetime with subsequent conditions. And then what happened is that B dies issueless. Okay, so A's nephew means uh, his nephew means when she step into and claim the property, because as per this section, if my nephew's daughter dies issueless, then we have mentioned that the property should reverted to my nephew. So when she claim the property under this branch 3, the court does did not basically grant the property to my nephew. And why the court did not grant the property to my nephew, so we further discuss in the next slide. Okay, so if you see the transfer again, so A transfer the property to B, who is nephew's daughter, and then these are the three conditions it has made. Okay, now first condition, if as a male child the absolute interest will be vested to him, And then in the second condition, it says that if she will have a female child, then again life interest, okay, will be vested on her. But this is, as I said, that for an unborn child, only absolute interest can be transferred, life interest cannot be transferred. So this was a, wrong condition which was in the deed. So as per this condition, this is void. As per section 13, an unborn female child cannot granted a uh, not granted a uh, as per this section 13, here it's supposed to granted the absolute interest, but life interest was cancelled. So that's why this condition went void, and the entire deed went void. And then the property reverted, instead of A's nephew, the property, if you see the code, nephew's claim was rejected, the failure to grant the absolute interest to the hypothetical unborn female child, and the subsequent nephew's claim was void as well, and the property reverted back to A's heir. Property reverted back to A's legal heirs instead of nephew. uh, the property went to the A's legal heir. So this was the very interesting and a landmark case study. I hope you understand this. And then there is a flow chart or algorithm, if you say, where we will further understand this section 13. Okay, so now transferring to an unborn person, proper under section 13, if there is a living intermediary, then if it is yes, then it will go further. If it is no, then the interest fall into abeyance, and this will be void. So if there is no immediate intermediate living intermediary, then it will be void. Then if yes, then the ultimate transfer is absolute. If no, then again it will be void. If yes, then it does the unborn arrives before the intermediaries dies. If no, then again it will be void. So if the unborn arrives before the intermediary dies, then it will be considered yes or true, and then this would be a valid transfer. So these are the yes section. First, there has to be a living intermediary, then it has to the absolute ultimate or absolute transfer has to made uh, to the unborn person, and then the unborn person must arrive before the intermediary's death, then this will be a valid transfer. So, and the final insight is the section 13 is ultimately not about the unborn person, is a structural safeguard designed to ensure that the property rights are never suspended or vacuum, guarantee the continuous absolute ownership all the time. Okay, so this was all about the section 13 of Transfer Property Act. So in case if you have any doubt, you can raise your question, or in case you want this presentation PPT slide deck to then you can share your email address. I will send this slide decks to your email directly. Thank you for watching this video. I hope it was a informative one. Thank you. Yeah.